Welcome to the Asureology Show, a growth hacker's guide to human capital management with your host, Mike Vannoy. Each week, we bring you experts in human resources, employment law, accounting, benefits planning, and more to build productive organizations. You'll gain practical guidance for your business. You'll be alerted to the latest news and mega trends that impact small and mid-sized companies. We'll give you the hands-on information you need to stay compliant with ever-changing employment laws, the strategies you need to win the war for talent, and much more, so you can focus on what you do best, growing your business. Enjoy the show.
Does your social media policy violate labor law? I'm Mike Vannoy, Vice President of Marketing at Asure, and help me unpack this topic. My guest today is Brian Shenker. If you're a regular watcher of the show, you know Brian. He's an attorney at the Long Island, New York office of Jackson Lewis. Brian's practice focuses on representing employers in a wide range of workplace matters, as well as preventative advice and counseling. Brian has extensive experience defending class action and collective action lawsuits under federal and state wage and hour laws. He has successfully defended wage and hour audits conducted by the U.S. and New York State Departments of Labor. And Brian regularly handles cases before courts and administrative agencies involving claims of discrimination, sexual harassment, and retaliation. Brian, welcome back to the show.
Thanks for having me, Mike.
Okay, so this is one of those things that you don't have to go back that far. You never would have thought was a thing that you had to have a policy around it. But social media has just become such an integrated part of most of our lives, right? That maybe you didn't think you had to have a policy for when and how to use a cell phone when they first came out in the workplace. But now mobile phone is kind of synonymous with social media because we really do live our lives in this very integrated way. Sometimes my boss might even ask me to post something on my LinkedIn profile about work. Maybe while on LinkedIn, I'm chatting a friend. Maybe I'm in Facebook, Instagram. Maybe I'm just wasting time and I'm not working. I'm scrolling through TikToks. I mean, this is a complex area with lots of areas of gray, I would think. But there's probably more black and white than most employers realize when it comes to law. Would you agree with that?
Yeah, that's true. And right, social media has really developed at such a quick pace over, really the last decade or so. But when it comes down to it, a lot of the things we'll discuss today are simply applying other policies that a company should have in the social media context. Now, there obviously are challenges to that and certain intricacies we'll get into. But yeah, a lot of this stuff, a comprehensive social media policy will, for instance, include your, anti-harassment on social media. So some of the things really just transfer right over. But right, of course, there are other, issues that can be less intuitive for companies.
So let's just start with the basics. This might sound self-evident, but I think it sounds self-evident in the name, but very few people, I think, as a percentage of especially small business owners, have it in place. What is an employer social media policy? What's the goal of it? What are you trying to accomplish it? What's the purpose of it?
Yeah, so I think you hit the nail on the head, right? Before we get to what the policy should include, right? What's the goal? What are the issues here? A lot of the risks with respect to social media include things like employees misrepresenting the company's view on certain topics, or inappropriate non-business use of social media, potential disclosure of the company's confidential information, as I mentioned earlier, harassment. And so in crafting a good social media policy, an employer should, consider, it a comprehensive thing, right? They're going to look at, what are the other rules that we have for the workplace, and, how do those apply here? And so, right, those are some of the main considerations that we have. But in terms of specifics, in terms of the policy, I
Yeah.
think the first thing is, as you said, social media is constantly changing. Whether it was Facebook, going back several years. Now you've got right TikTok, Twitter, Instagram, all sorts of different types of social media. So in defining social media, policy should really define it very broadly, right? Because we don't want our definition of social media to become outdated a month after going into the handbook. So
Yeah.
it's
Right.
generally going to include things that are done on online platforms, whether social or professional, posting commentary or opinions or sharing pictures, audio, video online. In all types of online communities. So that's what we're really talking about, in terms of what is,
So we probably
social
won't go
media.
too much deeper on the what it is, because we're going to get to some of the don'ts and we're going to talk best practices. But I think we first probably have to understand what the law actually says. So the law is the National Labor Relations Act, and certainly that's broader. That's not a social media law per se, but social media is included in this. Can you maybe start casting a wide net? Just explain what the NLRA, National Labor Relations Act, is, and how is it that governs social media in the workplace?
Right. So, great. Yeah, I think that's where we should start exactly. So the NLRA is, goes back, I think it was enacted in 1935. And many employers have this misconception that it only applies to unionized companies. But there are certain sections of it, particularly here, we're dealing with Section 7, that deal with employees' right to, act and discuss terms and conditions with their coworkers. So that's what we're mainly concerned with here. And right, in terms of social media policies, again, it's how the policy, and there are lots of different policies we can go through, affect employees' ability to discuss their terms, whether it's compensation or benefits or scheduling. And one thing to always keep in mind with the NLRB, which is the National Labor Relations Board that enforces the act, is that it is certainly has political leanings, right? Because the board and the general counsel are appointed by the president. So we tend
Okay.
to see shifts in enforcement and positions on lawfulness of various things depending on the makeup of the board. So certainly right now under the Biden administration, we can expect that the NLRB might take closer looks at social media policies and whether they impinge on protected concerted activity. That's the term today. Protected concerted activity, fancy way of saying more than multiple employees coming together to discuss, conditions of employment.
Got
So,
it. So 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 so
uh,
so the the origins of the law really are more about protection of workers' rights when it comes to unionizing and organizing, right? Organizing to a single voice. But where it spans into social media, it's more specific than the use of social media, and ties back more to the types of speech that is protected, as underpinned by really the core meaning, the main gist of the NLRA. Am I saying that right?
right. No, exactly. And so what we're really looking at when, a company implements a social media policy is we keep an eye on, right, whether it's what it's restricting, right, and how much employee interaction or conduct it's restricting, and what the purpose is. So even a social media policy that's neutral on its face, the NLRB will look at the potential impact on employees' rights and whether the company has a legitimate justification for having that policy. Um,
Okay.
so, when we look at these decisions from the NLRB, the context of the restrictions matters significantly, right? So, for example, in the healthcare or pharmaceutical industry, there was a policy, a company policy that it was necessary to ensure that rather they could limit social media activity to matters unrelated to the company if necessary to ensure compliance with securities and other laws. And so this policy restricted employees from disclosing confidential information of the company, including, personal health information of customers. And right, that was found to be lawful because, while an employee might construe that policy to restrict them from communicating about certain terms of employment that the employer might deem confidential, clearly the intent of the policy was to restrict those proprietary type of things and, patient information. And it wasn't designed to prevent discussion of workplace, conditions.
Yeah. So
So what
maybe,
we often suggest. Yep.
yeah. So what prevents a company, and this is maybe where you're going, so forgive me if I cut you off, you know, maybe I'm an employer. I'm like, you know what? These lines are too blurry for my taste, and you shouldn't be on Facebook and Instagram and TikTok anyway because I'm paying you to work. Um, get back to it. And our policy is no use of social media in the workforce. It, because I'm not explicitly saying the types of things you can't do. Am I in safe ground just setting that policy? No social media in the workplace.
Yeah, so potentially, right. We would have to look at what that implicates. Does that mean that an employee can't use their phone to take a picture of a work condition? Now that's probably not social media, so you would be fine. But
Yeah.
saying certainly something about using social media while working is something where a company is going to be on much better ground than some broad requirement, that goes, beyond the workplace. Um,
Got it.
so, there are all sorts of things that companies might do that the NLRB could be, find unlawful. Like, for instance, disclaimer requirements, right? Some companies are very concerned that employee statements on social media might be construed as a position of the company, right? And that's a big issue for companies, right? You don't want an employee going out there being associated with the company and having a negative impact on the company's brand.
Right.
So there's actually an NLRB advice memo on that that determined that basically companies have a legitimate interest in having employees identify themselves on social media as employees of the employer, and that they're making a post that could be considered on the employer's behalf, that they make sure it's expressed on their personal opinion. And
Can we
so
can we
but again,
can
these
we
are
feel
gray
that?
areas, right?
Yeah, can we feel the boundaries of that one out? So if I'm on LinkedIn, more of a business platform, I'm clearly signifying who my employer is, and I make a post or I comment on someone else's post. That's basically, it's pretty clear I'm talking crap on my employer, my boss, my industry, or something. Because the platform itself lends itself to whom I'm employed for, is there an implied affiliation that you're speaking on behalf of the brand?
Right. So it depends. Not necessarily. I mean, there were other ones. There have been other board decisions that have said, a requirement that employees identify themselves by name when making those comments, went too far.
Hmm.
And that so there are some again, it's also, fact specific and policy specific. But for instance, just generally, you know, provisions that you can't go out there and disparage your employer may are typically going to be, invalid, right? So,
Yeah.
because those could be, those really implicate discussions about employment terms. So if, you might go on LinkedIn and, you're associated with a company and you start a conversation about, you know, my the scheduling at this company is really awful. The managers, really, make it burdensome for employees. And then maybe another one of your coworkers joins in that discussion and comments on it. Now you have concerted activity where you're potentially talking about terms and conditions. So when we look at policies, right, a policy that prevents employees from disparaging the company online, that's not going to pass muster because it prevents that type of thing.
Got it.
But there are narrower ways to address that, right? You could have a provision that prevents employees potentially from disparaging customers or such. And again, it all depends on the specifics of the policy, but yeah, it's very interesting how the board will look at these things.
So the essence of the law, and it just coincidentally cascades into social media as a form of speech. Am I thinking about that the right way?
Sure.
Yes. So it just coincidentally cascades into social media as a platform as for this protected speech. The policies must really center around not preventing employees from talking about legitimate business employment concerns, whether it's safety, discrimination, work environment, etc. So any policy you make, any social media policy, has to be focused on that. Is that right?
Sorry. So yeah. So, there are other policies, for instance, like, confidential policies, right? So clearly, an employer has a legitimate interest in preserving their, confidential information. But, there are, various NLRA decisions where they found that employees have the presumptive rights to disclose terms and conditions of employment. So really, a lot of these policies should, involve examples, right? I think social media policies are really good when they include examples of what we're saying to really clarify that, this policy about not, disclosing the company's confidential information, right? Let's give an example because it's not about, hey, you can't disclose your compensation, right? We're not saying that's confidential. But it might be, more trade secret information.
Right.
Uh,
Right.
you know, so, and look, there are also other, company policies that we've seen that have been invalidated, such as, because companies go about this, you think of creative ways to restrict potential negative impacts. So, we've seen company policies that require that you're always honest and accurate when posting information on social media, which doesn't sound so bad, but the NLRB has concluded that employees have the right to make inaccurate statements, as long as they're not, maliciously, defaming.
Yeah.
But that, even those types of accuracy requirements, can run afoul of the law.
Yeah, there may not be such a thing as alternate facts, but there is alternate opinions on facts, right?
Exactly. And so those are the types of things that you can see, right? If I'm an employee and I'm subject to a policy like that, it's going to chill my speech because now I'm concerned about, is everything I'm putting online completely accurate? Am I going to be disciplined for putting something out there that's inaccurate? and that has a chilling effect, which the NLRB would find unlawful.
So
So
what can an employer do? I mean, because you don't want. I mean, you can say at the end of the day, if if you're hiring the type of people and you're creating a type of an environment where people feel the need to go to social media to talk crap about your business, then you probably got bigger problems, right? You got a culture problem, you got a talent problem, you got a business problem, you got a management problem, a leadership problem, you got a bunch of other stuff that's probably way more important to focus on than your social media policy. But it's also reasonable for a business, maybe a business who's doing everything largely right, and you could have one employee that sees the world through a very distorted lens blow you up pretty bad. And so where's the line around, maybe defamation is too strong, but where's the line around allowing and protecting their free speech as guided by the NLRA? At the same time, hey, you can't. What you just said might be your opinion, but it's not true, and it's hurting my ability to attract new employees and new customers.
yeah. So exactly. So really, where that line is drawn is at personal gripes, right? So the NLRB will not consider social media to be that concerted activity when it's merely reflecting the employee's personal issues and doesn't involve a broad workplace issue. For instance, in a Facebook post that when an employee complains, that there's not enough funding or not enough vehicles or something to perform their job. But if there's no evidence that this was part of a broader discussion or that employees were bringing these issues to management, that won't be you could discipline an employee for that. Similarly,
Okay.
A Facebook post about a bad interaction with a manager, right? That the real question on a lot of these posts, online posts, is whether other coworkers start engage in the discussion towards these workplace conditions, and that it's something that would be brought to management, right? Because it's the same thing. If employees were discussing this in person, it could be protected. But for instance, if an employee just posts that themselves on Facebook and there's no other interaction with coworkers, or the coworkers aren't commenting, "Hey, I've had experiences like this too," but just saying, "Hey, I feel for you," that stinks. Then those things, when it's just providing emotional support, for instance, to someone who has this personal issue with the manager, that's not protected activity, and an employee could be disciplined or terminated. Likewise, an employee who, posts something real derogatory towards customers, right? There was, one NLRB matter involving an employee who said something along the lines of that, he wished, the employer's customers would choke in that, and use some derogatory term towards them. And, the NLRB found, regardless of whether other employees would engage in this discussion, that it had nothing to do with the terms and conditions of employment. So yeah, absolutely. When employees make those types of comments, if it's not towards the terms and conditions of employment, then the employer can do something about it. But when there's sometimes a gray area, right, where the NLRB has found that simply an employee who posted something online criticizing the employer's tax withholding calculations, and one employee commented on it, kind of agreeing with it, that then became protected activity. So I think the concept is we want to be careful, as an employer, if you're going to start when you're going to govern online conduct.
Yeah.
we'll discuss other issues, but as it relates to the NLRA, really what we're looking at is, number one, does this relate, does the comment relate to terms and conditions of employment? And two, is this a group? Is it, just a single employee, saying an issue? Because that's not concerted activity. It only becomes concerted activity when there's more than one individual, engaging in this. So then, look, there might be multiple employees, trashing a manager on, Instagram or Facebook or what have you. Could even be, an email chain among employees where they're just saying real horrible things about this person. But if it relates to the work and not just, personal issues, right, then it's potentially, protected. And while it might absolutely offend the employer that this is being stated and possibly in a public manner, it's not necessarily actionable by the employer.
Let me ask this. So, like my kid's school, they have social media anti-bullying policies, right? So that would seem to me an area that it's not talking about coworkers and them personally, not the work that they perform. It's not even about work at all. You're not saying good or bad things about your employer. They just happen to be coworkers. But the online bullying can be a very serious thing, right? What can or should an employer do there? And is it, I suspect not, but is that governed by the NLRB then?
So to start with your last question, potentially it is covered by the NLRB, but when it comes to harassment and discrimination, I think what employers should really take away is that just because the harassing conduct is occurring online doesn't make it any different than harassing conduct that occurs in the workplace. So, an employer's social media policy should absolutely remind employees that their, EEO policies and, sexual harassment policies apply equally to their social media conduct as they do to, in person. And so I think, the company could have a policy that, prohibits, threatening or obscene social media posts and, can provide examples. But yeah, I think invoking those those policies and with specific provisions, so that it's not overly vague, that should get the company around, any, concerted activity issue under the NLRA.
Okay.
So for instance, you could have a very simple statement that your social media activity is covered by all the company's policies, including, the company's equal employment opportunity, non-discrimination, anti-harassment policies, and that, you should not post any content on social media that violates, these discrimination and harassment policies. And that should generally, be okay.
So you do, as an employer, have the real opportunity to set out these, these types of policies that are not about protected speech around, workplace safety, environment, traditional NLRA kind of stuff. But you can, just as you could have a no bullying policy that has nothing to do with social media could reasonably be included in your anti-bullying policy, right?
Absolutely. And same thing. Yep. Go ahead.
Yeah. And so same thing about, maybe I'm thinking, I don't know how to put it, but maybe you're like relationships in the workplace, right? It's like, okay, young man, there's clear policies around sexual harassment that are maybe clear about what is and is not out of bounds in the office per se. But if I'm connecting and I'm making advances on this other person because I'm interested in them and via social media, I mean, what's inbounds and what's out of bounds there?
Right. Exactly. And so there, some companies even employ, a provision that prohibits managers from quote unquote friending subordinates on, non-professional social media sites, right? As, that could be, construed on, as intruding on the employee's privacy and, potentially lead to those types of, social or, even going beyond social issues between, a supervisor and a subordinate. So
Say
yeah,
more
I
on
think,
that, Brian. Do you have any use cases? Because I could totally see that. It's like, I just hired a new person on my team. I'm a 54-year-old man, and I just hired this 25-year-old young woman, and I want to be able to do effective marketing. So I friend request her on LinkedIn. That feels appropriate. Feels kind of creepy if I did that on Instagram or Facebook.
right.
Is it your
Yeah.
recommendations that employers set policies to prevent those, or is it? It almost feels like you couldn't create enough policy to cover all of the one-off nuanced edge cases, that maybe it's more principles than it is policies. I don't know. What are your thoughts on that?
Right. I agree. I agree. It's tough to say, right? Because, if a manager is going to be, connected with someone on LinkedIn, then, why not on Facebook? But, you can think it might not just be, the romantic related, issues, but, you have a manager that becomes friends with someone on Facebook. Now the manager and, you know, really that means the company has a significant amount of personal information at its fingertips about this
Right.
employee, whether it,
Yeah.
discloses their sexual orientation or,
Right.
a potential disability or, a variety of things that could be considered protected categories. And, so a company might not want that, right? Even if there's not an intention to take action or do anything based on those,
Yeah.
it
I mean,
potentially opens the door for an employee to claim, right?
yeah. I mean, give the old guy benefit of the doubt. He was just trying to be friendly and be quote unquote friends. So sent you a friend request, but there's this. I would assume that there's this. It could be, not all cases, it could be an uncomfortable feeling of responsibility to accept the friend request. Like, oh my gosh, what if I say no and decline? What are they going to think of me? Will there be retaliation? So, but if I accept, now they're seeing all my personal life of whatever that might mean, in all kind, everybody's got their
Yeah.
personal lives, but I mean, all kinds of
Right.
protected class kind of information that could be revealed.
Yeah. And I think that's why when it comes to, supervisors and subordinates, drawing the line at, professional relate, social media, professional groups, that's fine. But it's likely a good idea for companies to consider, cutting that off for the non-professional sites because, like you and I could sit here for hours thinking of all the possibilities
Yeah,
that
right.
could come up, right? From that type of knowledge or what a supervisor, might comment on, some, photograph, things like that, which, again, because, you know, a lot of times, managers and employees in general too, they understand what's appropriate in the workplace, and there's this just common belief that what we do in social media and online is just something completely different, but it does relate to the workplace, and inappropriate interactions online are just as inappropriate and actionable as inappropriate actions taken in person.
So let's say more about that. So if I'm a school teacher, I mean, it seems rather obvious, and maybe I could have social media policies that explicit me posting, some explicit pictures of myself, or access to websites where you could see explicit pictures. Uh, but what's different about that in social media versus that school teacher, maybe works at an adult establishment on the weekends and performs those private. I mean, but where is the line of where is it? What is an employer's right to say that's not an okay thing for our employees to do, even if they're not in the workplace? And then how does that tie back to social media?
Right. So no,
Because I think this is where people get in trouble, right? It's like,
yeah.
okay, good performer in the day job. I had no idea you were a snake handler, and that creeps me out, and I don't want you around my. I mean,
right.
That aren't work behaviors, but
yeah.
Go ahead.
Yeah, I think that the question will often come down to, right, is there a legitimate purpose? Is there a legitimate reason for the company's position on this, right? That so again, if this person has some personal social media that's unrelated to the company, they're not posting about that these photos or whatever that is them on behalf of the company, then that's probably going beyond the bounds of what the company should be regulating on its social media. I think if we kind of think of social media regulation by employers as just an extension of their other policies, right? Then we're thinking, all right, is this impact? Are they doing this on work time, right? Because I'm
Yeah.
sure there's a policy in the handbook saying you can't have other employment that interferes with your current work. So is it doing that? Probably not. And so are you divulging company confidential information? No. So we want to look at what these other company policies are, right? Are they doing they're not doing it on work time? They're not disclosing company information. They're distancing themselves from the company. They're not saying that anything they're doing is on behalf of the company, or that the company has authorized them to sell these services. Again, are they disparaging the company? And if they're disparaging, is it concerted activity? So again, I think that's when it goes into balancing the employees' privacy rights with what's legitimately a business related issue.
I want to get into some examples of areas where you've seen employers get in trouble, because I feel like this conversation is like intellectually interesting, but there's so much gray that I want this to be helpful for folks. Before we get to the specific examples, my sense is that if I'm a small business owner, and you say that I'm not paying my people correctly and I'm going to be in trouble with the Department of Labor, I have a sense for what that might look like. If I'm employing people without legal documentation and ICE knocks on the door, I have a feeling of what that looks like. What does it look like to be in trouble with the NLRB? I don't think most employers have a sense for what does enforcement look like? What kind of teeth do they really have?
Yeah, so enforcement can be pretty broad at the NLRB. So, in the first instance, right, if, typically an issue with the social media policy is going to come up in the context of the company having terminated an employee for violating some policy, right? So then the NLRB is looking at two things, right? One, whether that policy is lawful, meaning, right, whether it has this restriction on concerted activity, and whether that outweighs the company's business interests, and two, right, whether it was proper to terminate the person. So the first part, just the the policy. All right, so your policy is unlawful. You need to change that. Of course, there can be some monetary component, which the NLRB has broad discretion of. But really, where they'll get you is on the termination, right? They have the ability to require an employer to reinstate an employee who's been terminated, pay back wages, and all sorts of other connected damages that the employee suffers. So that's where the danger gets here. That an employee is terminated or even disciplined. It doesn't require a termination,
Yeah.
but discipline for violation of a social media policy that you know really involves concerted activity. Um, so just for an example, right? Um, there was an NLRB case where employees posted criticisms of a manager on Facebook for not letting them leave early, right? It doesn't even matter whether they were entitled to leave early or not.
Right.
But the fact that multiple employees came together and were, engaging in a Facebook discussion, and the company saw that this was happening and they decided to terminate those employees, and the NLRB said it was unlawful to do that. So now the company is either going to be paying wages, back wages to those people, or having to rehire them.
Yeah. So
They're
are there statutory is there statutory accountability, like X dollar fines or explicit consequences, or is this kind of up to what the NLRB says? I mean, give a sense for how big of fines or repayments and stuff are we talking about?
It's not necessarily statutory fine like a lot of the other laws. The NLRB really has wide discretion, and the current NLRB general counsel has been issuing some guidance and memos that kind of expand on the NLRB's ability to provide various damages, impose damages to redress unlawful conduct. So yeah, I mean, look, back wages can be tens of thousands, if not hundreds of thousands, depending on the length of time it's been since someone was terminated, and potential interest, and look, so it can range from very small to quite large. Oftentimes when there's an NLRB finding against an employer, there's a posting requirement. So there's notice that will be required to be provided to workers. So that's obviously a potential issue for employers. Not to mention just the expense of an NLRB proceeding, right? So you're going to have to deal with the NLRB coming in, instituting a proceeding which is at the NLRB. It's not in court per se. There might be appeal rights, but it's an NLRB proceeding. And I guess what I can say about that is most employers would much rather be in court than at the NLRB. There's
Why is
limited discovery. There's limited discovery. There are limited procedures. It pushes companies towards hearings, essentially a trial, much quicker than court, and so it can be difficult for an employer. It's not necessarily the preferred forum for companies, and look, especially because the board is so politically driven. Especially as the board is constituted now with a majority, Democrats, enforcement will ramp up and be expanded when this is the case. So that's what we tend to see.
So it does have all the legal teeth of if you get into a wage and hour hearing by your state's Department of Labor, you might not be in a court, but this has the same teeth as that, right? You don't get to say, "Oh, that's not a law. That's just the board, and it's a political organization. Screw them. I'm not going to show up." I mean, all the same consequences of whether you show up, whether you participate, in whatever decisions they make. Totally. Right?
Absolutely. Yeah, it's a legitimate, government agency. They can enforce, their decisions. It is, I'm sure any of our listeners who, have union workforces are quite familiar with the NLRB.
Yeah.
and probably may know from experience, that they're to be taken seriously. For employers in the private in private areas where there is no union, right there may be this perception that the NLRB doesn't apply to me. If they come knocking, it's no big deal because I don't have a union. But that's not the case. And really, this Section 7 protected concerted activity is really the NLRB's teeth to get into private employers, right? Where when you have workers, discussing, terms and conditions of employment, whether it's in person or on social media, there needs to be special care taken if you're considering discipline for something related to that, because that is a protected right even for employees of private employers that are non-union, that they can discuss. And look, sometimes it's in disparaging ways. It's not always gonna look so nice, and that's all often where the issues come up from, where the employees are saying some real negative things online, right? Where they might be talking about poor work environment, calling out managers. But if there are multiple employees engaging in this, and it's something that they might or have complained to management about in the past, then it's not just their own personal gripe. It becomes something
Yeah.
about conditions of employment, and it's concerted activity and potentially unlawful if you're going to take action against the employee because of that.
Brian, I'm assuming where this shows up most of the time, the enforcement aspect, that is, it's not like there are an LRB police knocking on doors, but this is an employee, probably most commonly the result of some type of retaliation. Employee puts something online, employer takes some action, termination, suspension, some disciplinary thing, or just even if they reacted reasonably, then employee says nope. I have the right. You don't get to tell me what to do. This is protected, and they go get a lawyer, and then the person on the other side of the aisle from you, their attorney, they're the ones who know how to navigate what is required by NLRA and engage the NLRB to take action. That's probably the path this takes, right?
Exactly. So one of the things that we see is, the employee might go to the attorney first, and maybe the factual scenario provides for a sexual harassment claim, but that it also implicates the NLRA, that we see duly filed matters, where there might be a state or federal claim for discrimination, and simultaneously that employee will file a charge at the NLRB under for an unfair labor practice related to Section 7 concerted activities. So while
Yeah.
their attorney won't represent them at the board, right, at the labor board, it's the NLRB has their own counsel that will handle matters on behalf of these employees. But yeah, it's not uncommon to see that, especially when it comes to retaliation. And sometimes that can even be, right, we see, wage and hour cases, right, where there's, let's say several, 4 or 5 employees that file a wage and hour complaint, for unpaid overtime. And, they also claim that a manager, terminated 1 or 2 of them because they got together and complained about tips being stolen from them, or not being paid that overtime. And so you might also have a wage and hour retaliation claim, but if there were multiple people coming together about these issues, you also have a potential NLRB charge for the employer, and they will, the NLRB will go after it just as zealously as the private attorney will go after the wage and hour component. And
Sure.
that can be real burdensome when a company has to deal with multiple claims in two different forums, especially since as I said, right, the NLRB matter is probably going to move faster than something in court.
So I want to go down a different rabbit hole for just a second, just because it relates to social media. I don't think this is necessarily, and maybe it is. I don't think it's necessarily NLRA oriented. um, what can employers require or are not allowed to require? So we talked a lot about prohibiting. As an employer, you can't prohibit this, you can't prohibit that. You've given lots of examples I think are helpful. But let's say I want my employees to be an extension of my sales and marketing function. And if I'm having an open house or I'm promoting a web show like this, can I require my employees to promote this and post this on their LinkedIn, their Facebook, their et cetera? Maybe can I do it on LinkedIn because it's a business platform versus I can't on a more personal. Where are the lines there?
Right. So no, that's a great point. And yeah, the law in that area is developing. I think generally it's allowable to ask employees to do that. Again, if it's a personal account, so even if it's their LinkedIn account, and that's professional, right? That's a professional personal account. So it might be something that you request employees do, but again, we could run into issues of requiring them. And this also gets into another tangent, which is quite interesting, which is, so it's absolutely fine to, have a company account, right? So you could create, whatever it might be, a company account on, Facebook or LinkedIn, and, your marketing employee is running, the Facebook account for your company. And so, right, that's the company's account. You can require them to post on that. That's part of their job. But an issue that many employers overlook is ownership of that account, right? So we ask our marketing director, create us a LinkedIn and Facebook account for the company. All right, that director has the login and password information. They've created it, and all is good while they're working. When they quit or when they're fired, what if they take that login? Right now they're saying, well, I created it.
Right.
It was it's my work, but the company is saying, well, you have our company contacts, right? We're losing the account. The people are looking to us, and you're connected with all these people. We need to know who they are. That may very well end on the employer's side, but I think the law is really developing, and there's no real clear answer on that. But what employers can do is say, if you're using the company account for marketing, that is owned by the employer, and you can include language to make that very clear.
Yeah.
So there are little intricacies like that, but yeah,
Yeah.
requiring people to post on their personal accounts, might not always be the best thing.
Well, and the reality is, some are obviously more business oriented, like LinkedIn versus Facebook or TikTok being personal, but they're all personal. I mean, it's
Right.
your personal Google account that you have to, and you got to have a Google account to be able to set up a Google AdWords to run ad campaigns. You got to have a Facebook account to set up a Facebook business page, right? You got to have a LinkedIn, a personal account to set up a LinkedIn company page. So they do get intertwined.
Yeah, and another related issue is, that if you do have employees who are posting, if it's, testimonials or endorsements about the company's services, that is potentially covered by the FTC, the Federal Trade Commission, and the FTC has guidelines regarding individuals who give endorsements about a company's services or products, that they must identify their relationship to the company. So an employer who might so if employees are going to be doing that, the company should recommend that if an employee posts about the company's products or services, that the employee states they are an employee of the company, and that their views are not necessarily those of the company. So
Yep.
yeah, there are other laws that potentially come in and dictate what happens in that scenario when the employees are using their accounts for business related matters.
Got it. So this is a hard one to this topic today, Brian, because I feel like you gave a ton of really specific examples, and my sense is that anybody who watched today's show still might be unclear of where the boundaries are when they set up a policy. Can you try to kind of package this up to wrap the topic? Here's what should you or shouldn't you have a social media policy, and if you do, here's what you shouldn't do. The top 3-4 things. Here's the
Yeah.
top 3-4 things that you should include in it.
Absolutely. So, with respect to a social media policy, definitely have one. It should be in the handbook. May very well be good guidance to have a separate standalone policy so that employees are reminded of it. What should go into it? Again, a definition of social media. We want to reiterate that other company policies like EEO policies apply to online conduct. We want to address work usage, right? Whether or not employees are permitted to use social media while at work, to what extent. You want to include in the social media policy protections for the company's intellectual property and confidential information, right? And these are probably things that are in your handbook already, but you want to include those in the policy, right? And this can address recording of non-public proprietary things, right? If you build rockets, you don't want employees taking videos and showing how you make those rockets, right? So things like that. We want to make sure there are provisions in the policy that distance the company from the employee, meaning that you as the company cannot control all the things your employees will say and do online. And therefore you want to put it as much as you can in that policy that reduces the risk that the company will be associated with certain bad behavior online. So for instance, that means written authorization is required to speak on behalf of the company. I think that again, I just went through endorsements of company services, and then again, we discussed earlier the policy should consider privacy rights, right? Whether supervisors should be friending subordinates, and again, one of the big things again is the Section 7 NLRA rights. So we want to make sure that we're drawing attention in the policy that and again, I advise this go in every social media policy, a savings clause. An NLRA savings clause essentially says that nothing in this policy is intended to limit protected concerted activity. And it's exactly what it sounds like. It's in case there's any lack of clarity, the company is explaining that it's not intended to inhibit those rights. And then I think a last thing would be that for companies that use intra-company social media, right, that there are various platforms, and it may or may not really be social media, but it could be messaging, that companies can restrict that a bit more, what can be used. But again, it shouldn't just be one of those things that it goes without saying. Take the opportunity to address all these concerns in your policy, because without it, employees will do whatever they feel like. And hey, they still might, but if you have an appropriate policy, then you'll be in a better place if you need to take action against employees for engaging in some type of inappropriate, social media conduct.
Yeah, that was a really good recap, Brian. Thank you. I think as in so many things, HR laws are kind of black and white, but for employers, staying compliant is less so. There's no law that requires a job description. There's no law that requires a social media policy. There's no law that says you have to have a formal interview process. But all those things are best practices that help you not only find and retain the best talent and get the most out of a highly productive team, they're also the things that help keep you out of trouble and stay compliant. So I think this is one of those areas easy to dismiss, easy to overlook and think we don't have to do anything here. But good compliance starts with proactive communication. Proactive communication in a consistent way looks an awful lot like a policy. So I think this is what felt like a bit of a nebulous topic as we talked for an hour. I think you brought it home. And at the end of the day, you really do need policies, but you got to understand what the laws are to know what you're protecting against and for in these policies. Anything else you want to add in closing here, Brian?
No, I think you're exactly right. And look, this is a new area, for many employers, right? But, social media, whether, your company, actively has social media or if you're just addressing, employees' social media, I think it's very important because it is something that, as we talked at the beginning, there are risks. And if for no other, workplace risk other than, social media can impact, your business's brand and how the public perceives it, no matter, if you're a small or large company, and having a policy in place that's distributed to employees that they understand, that provides examples, because as you said, there's a lot of stuff here to unpack. So a lot of times examples can really help employees, understand what they should and shouldn't be doing, and helps the company, avoid, potential violations of the law, by narrowly applying its policies. But, it all can be really helpful in a number of ways to a company to address these issues in a policy.
Yeah. Very good. Brian, I always enjoy talking to you. Thanks to you and thanks for everybody else for joining us today. Until next week's show, have a great week.
At Asure, we build human capital management software and services that help 90,000 companies like yours attract, develop, and retain great people. Our low upfront costs and affordable subscription model allow you to save cash to invest in things that drive growth, not overhead. To learn more about how Asure can help you claim up to $26,000 per employee with the Employee Retention Tax Credit, automate your payroll, and build productive teams that are compliant with ever-changing HR laws, visit AsureSoftware.com.